Welcome, everyone. We are just going to give it about a minute or two before others join. We are very excited to have you all listen to both myself and Gerard Filitti discuss the new face of Jew hatred, which is anti-Zionism. Um, well, just people are coming in. We're really excited. Um, I want to honor everybody's time. So in about 1 minute, we will officially begin. Okay, great. More people. Exciting. All right. So we really want to honor your time. Thank you so much for joining our webinar, The New Face of Jew Hatred, Anti-Zionism. Today, I am joined by Senior Counsel of the Lawfare Project, Gerard Filitti. We will begin with myself. I will describe the history briefly and the manifestations of today's Jew hatred, which is anti-Zionism. And I do want to qualify by today, I do not mean post October 7th. Anti-Zionism is a movement that was created in the Soviet Union in around the 1960s. The turning point was the Six-Day War in 1967. It was shipped to the West effectively right after the Soviet Union collapsed. The phantom legs of that campaign that they had created had immediately disappeared and found a new home in the West. And it's really been haunting us since the 1990s, really, on our college campuses. But it began to really amplify in the early 2000s. And the reason is I dated to the early 2000s is that there were three major world events. There was the Durban Conference in South Africa, 9/11, and the Second Intifada. And these three world events really provided fertile ground for this anti-Zionist hate, anti-Jewish hate movement to find a home, and it found a home in universities. And the reason it really found a home in universities is because professors, academics, post who believed in post-colonial theory really adopted the anti-Zionist worldview. And with that, I want to share my screen. I'm going to speak probably for about 15 minutes, maybe less, to kind of lay out what I've been talking about. If you know me, by the way, my name is Naya Lekht. I'm co-founder of Stop Antizionism. I've been writing about the history of Jew hatred for many years. I'm a teacher and educator. And with that, I would love to begin sharing my screen. So Gerard, you give me a thumbs up if my screen is being shared.
It's being shared. Perfectly good.
Okay, perfect. Well, anti-Zionism, the hate movement of our time, an old hatred repackaged in today's social justice language and how to fight it. Today, really briefly, I want to talk about how you know when something is anti-Jewish bigotry, and I want to introduce you to the three era framework. And then the last part is where Gerard will really join to talk about what we can do from a legal perspective. So when we talk about Jew hatred, we're very well prepared to identify and denounce it when it in the form of racial anti-Semitism, this idea that Jews are vermin and subhuman, that they want to control the world. Images from Nazi era, like this Jewish spider who's going to basically bite this Aryan woman and suck her blood, or the octopus, which is really the manifestation of the protocols of the Elders of Zion, this idea that Jews want to have the secret plot to control the world. And of course, the Heil Hitler salute and blood libel. These we are really well prepared to identify. And we know this because I work with many schools, public schools and private schools in California and New York. And whenever there's an instance of a swastika etched into a desk, there's immediate action. If there's, you know, a Heil Hitler salute that a student does, there's immediate action. But what about this type of discourse? What about this type of language where Israel is being told that Israelis are the new Nazis, that Israel is an apartheid state, that Palestine has been colonized and needs to be decolonized, and that Zionism is racism? And so for years, you know, I encountered it as an undergraduate student when I was up at UC Santa Cruz in the early 2000s. In 2005, SJP, Students for Justice in Palestine, instituted what is happening now, by the way, in the springtime, all over North American campuses and in Canada, the Israel Apartheid Week. And I would go to school officials and I would go to even our Jewish organizational leaders and say that we have a real big problem and it's anti-Zionism. I was told, nope, this is criticism of Israel. This is political expression. And unfortunately, because it was designed by the Soviets to look this way, it was given that polish, we've been missing it. So, what is Jew hatred? Jew hatred, as Rabbi Jonathan Sacks, is a virus that has the capability of mutating and adapting to new conditions. He delivered this speech in the year 2017. And I, at the time, was teaching in Los Angeles at a private Jewish school. And I was teaching a class on the history of Jew hatred. And I found students, actually, when I showed them these images, couldn't understand that this was the new face of Jew hatred. They said to me, no, this is anti-Zionism, and they couldn't understand why anti-Zionism is indeed Jew hatred. So that particular speech that Rabbi Jonathan Sacks delivered really spurred and inspired me to start thinking about this idea that this hatred is very protein. This hatred has the capability of mutating. And when I started to kind of drill into that and think about that, I identified three distinct eras of Jew hatred: anti-Judaism, anti-Semitism, and anti-Zionism. There is a pattern. And the pattern is that the Jew is always cast as a villain, but not just any villain. The Jew is standing in opposition to whatever civilization deems to be moral at the time. So in the era of anti-Judaism, morality was understood as Christianity. The way to save salvation was through basically accepting Jesus Christ. And so the Jew was seen as quite literally standing in opposition of Christianity. Thus, the liable deicide or Christ killer was born. Jews were seen as violating the purity of the morality at the time, which was Christianity. The second era of Jew hatred, when it mutated, because civilization went through a sort of evolution where the Enlightenment compelled this idea of studying the world and understanding the world mostly through the idea of race and science and progress. And this time, Jews were once again cast as villains, but not as violating religious purity, but rather now violating the purity of race. And it does sound really unprogressive to us today, but in the era of anti-Semitism, it was indeed very progressive to cast human beings, to categorize them based on racial features. It was not just progressive, it was legitimized in the Academy of Sciences in German universities. And so Jews once again found themselves violators of the moral tenets of the time. Well, after the Holocaust, after that catastrophe, the world went through a third stage of evolution, and today's morality is enshrined around human rights. And so, how do you violate human rights? Genocide, apartheid, racism, colonization. And the Jew vis-a-vis Israel is once again recast as this demon who violates the moral tenets of the day. And so that basically, when you take a step back and look at Jew hatred as really a demonology, a demonization project, how do you effectively demonize a group of people? You identify what is moral and you say that these people stand in the way. For this reason, ladies and gentlemen, it is also a very difficult hatred to fight because it is a virtuous hatred. The person who buys into anti-Judaism or anti-Semitism or anti-Zionism believes that they are rescuing the world, that they are purging the world of the filth of those who violate in the era of anti-Judaism religion, religious purity, racial purity, the purity of human rights. And so, how do you actually construct really a demon? And this is an important vocabulary word for us to start using in the Jewish community. And that is the word libel. Libel is the delivery mechanism. I'm just looking at my time. Yes, libel is the delivery mechanism of how to effectively stigmatize and demonize a group of people. And a couple months ago, I was I'll be completely transparent with you all. I was using AI and I was trying to find a correlation that states that the best predictor for violence against any community, any minority, but in this case, let's talk about for the Jews, we're talking about the Jews, is the deployment of libels. And I looked at key violent events like the Kishinev pogrom, like the Beilis trial, like the Hebron massacre, like the Gaza disengagement in 2005 and the Intifada that predated that, and of course, October 7th. Each time there was actually a libel that was deployed before the act of violence ensued. And so I'm going to finish here and turn it over to Gerard. But the goal of tonight's really webinar is for me to provide that language and framing because I think that the battle we're fighting is on two battles. It's the cultural battlefield and the legal battlefield. And sometimes we wonder what needs to come first. So this is a screenshot from a high school in California where the teacher, the English teacher, um, posed the following LQ learning question. How do Palestinians resist the occupation, a blockade in their land? It was a given. Embedded in that question was already a given that Israel is an occupation. And this, guys, is called the colonizer libel. So each era, the anti-Judaist era, the anti-Semitism era, and the anti-Zionism era, has their own libels. So the anti-Judaism era, the libels are Jews are Christ killers and blood libel. In the era of anti-Semitism, race polluter libel, dual loyalty libel, Jews controlling the world libel. But in this era, in the anti-Zionist era, what we're seeing is the genocide libel, the Nazi libel, the apartheid libel, racism libel, that is Zionism is racism. And right here in that question embedded is that Israel is violating human rights. It's an occupier, it's theft of land. I'm going to stop sharing and I'm going to invite Gerard to this conversation. Um, and Gerard, what I want to begin by asking you is I have this following kind of idea, and I kind of want to ask you as a lawyer. When I speak to parents and they bring me this type of evidence from schools, from K through 12, mostly high schools, of these egregious cases of anti-Zionism, what often happens is these parents go to the administrators, school administrators, and they say to the administrators, we have an anti-Semitism problem. And the administrators don't understand because they've been conditioned to understand anti-Semitism to be the second era. Jews are racially impure. Jews are vermin and subhuman. Jews want to take over the world. And so they don't really understand why is this a form of Jew hatred? So my question to you is, what is keeping us from effectively being able to advocate for ourselves, um, both in the schools but also in the courtroom? Why are courts not seeing this as a form of Jew hatred? So that's my first question to you tonight.
And it's a great question. Thank you so much. I think that what we're seeing is we need to normalize what the definition of Zionism is and anti-Zionism is, because so far it's been very successfully defined by everyone else, not by the Jewish people themselves, not by Zionists ourselves. So that's the basic problem that we're encountering, whether it's in a court of law or whether it's convincing a teacher that something is amiss. Because as you say, there is that disconnect between this type of Jew hatred and the type of anti-Semitism that is more readily understood. When a kid draws a swastika, there's instant action when a kid starts to yell from the river to the sea and globalize the Intifada, which are all directed at Zionism effectively. There's that disconnect between that and Jewish identity. And I think that's what it comes back to. It's convincing courts, it's explaining to parents, it's explaining to schools and society the relationship between Zionism and Judaism. What it means to be a Zionist is part of Jewish identity and how that is defined. Because we've seen in the last few years, especially, we have been successful in getting colleges to understand that. Now, through OCR complaints, Office of Civil Rights complaints under Title VI, through litigation that has settled favorably, universities are increasingly understanding that Zionism is essentially synonymous with Judaism in the sense that it is a part of Jewish identity, or many Jews understand and believe it is part of our identity. So that makes it something that's protected, and policies have changed as a result. So there is that start of a recognition that Zionism is tied to our identity and that anti-Zionism is a form of Jew hatred that needs to be addressed under the legal recourses that we have for fighting discrimination. But this is only the beginning because we only have this case law, we only have lawsuits, we only have OCR complaints that have been successfully arguing this position for the last 5 or 6 years. We don't really go back further than that. So in order to make this stick, we need to have more action. We need to have more decisions, more settlements, more schools adopting these policies, and to normalize our own definition, our own experience, our own identity before it's completely taken over by those who oppose it.
Right. So obviously two questions immediately come to mind. And by the way, at around 7:45, 7:40, we're going to open up questions to the audience. But immediately two questions come to mind, and that is, we talked about this offline, is I'm in total agreement with you that Zionism is integral to Jewish identity. The first question is Jews who will tell you no. Zionism is not integral to Jewish identity. In fact, I'm a proud Jewish anti-Zionist. And courts will look at that and they get confused. They're like, well, we don't understand what's that about. Which dovetails to the second question, and that is, and maybe you can educate me here, does do courts need to have definitions of what constitutes hate in order to prosecute discrimination? In other words, do they need to adopt an IRA definition? Do they need to adopt an understanding that anti-Zionism is a hate movement in order for discrimination to be prosecuted? So those are the two questions I have.
Well, the first part of that is that courts are reluctant to get into doctrinal disputes about what constitutes religious practice. And we see this fairly often, or we have seen this fairly often with cases involving Christian churches of different denominations. When there is a group that is claiming a religious exemption, for example, or says that their faith, their practice entails A, B, and C, courts don't really go in to scrutinize that. They defer to the practice of religion itself. It's not, in America, courts don't want to define what someone's faith actually entails. So when you do have Jews that identify as Zionists, it doesn't really matter that there's some who don't. That creates more, I don't want to call it a logistical problem or diminish how much of a problem it is, because it really does confuse judges. It really does confuse administrators. But the corpus of law, what the law actually says, is that the court is not going to sit and evaluate religious practice. So if we are saying, if there is a plaintiff that's saying that Zionism is part of their religious identity, that plaintiff has strong precedent. There was a case about this, a Jewish professor who sued the University of Maryland a few years ago and won. Not Title VI, Title VII, which is specific to religious discrimination against employees. And she claimed that, because Zionism was part of her religious identity as a Jew, then what she was experiencing was illegal discrimination. And the court agreed. And the court explicitly said in that case that Zionism is part of Jewish identity, part of Jewish religion. So that is a distinction that I think is very helpful because, yes, there may be Jews out there, and there are Jews out there who argue that they're not Zionists. They don't believe in Zionism. Well, good for them. They don't get to decide or define how the rest of us believe. Now, this becomes a speech issue ultimately, but when it comes to discrimination, you can't discriminate someone against their Zionist belief when you're tying it to Jewish identity. And sorry, go on.
Well, no, because I think that this is really, really important because I often get that question, what do we do with Jewish people who are anti-Zionists? And my answer, and you could tell me what you think about that. My answer is that Most Jews in America, or most Jewish men in America, don't wear a kippah. Most Jewish people in America actually don't observe halachically Shabbat, but there is a standard for what we understand to be Jewish religion or Jewish faith or Jewish identity. And that, for instance, you're supposed to read from the Torah twice a week. Most Jews don't, but desecrating the Torah is a isn't is an act of anti-Semitism, is it not? So the fact that you have Jews who say I'm an anti-Zionist doesn't really matter. It's the same as Jews who say, well, the kippah doesn't mean much to me, right? Does that kind of
It does, but it's no different really than you have Catholics, and you do have Catholics who believe that abortion is fine, even though the Catholic Church says that it's not. That doesn't make them any less Catholic, except maybe to the Pope. But when it comes to courts and anti-discrimination law, they're still identifying as Catholics. They're still, but they don't get to dictate how a court treats anyone else who identifies as a Catholic or who has that faith. And same in Judaism. And I want to take a step back for a second and make that distinction between speech and conduct because I think it's an important one. The example I use all the time, and I'm sure some people have gotten tired of me using it, is from a Die Hard movie when Bruce Willis, Detective John McClane, is back in New York City, and he killed a terrorist. And the first one, the terrorist brother wants to kill him in this remake. And he is told by this terrorist to go and stand in Harlem in the middle of a black neighborhood, naked, except for a sign that says, I hate the N-word. Now, that's racist. Everyone knows that that's racist, but that's not illegal. That's free speech. You can say that. There are consequences for saying it socially, and there are definitely consequences if he acts on that racism. If you discriminate against someone, if you deprive them of access to a building, to an educational opportunity, acting on it is illegal. So when we're talking about Zionism, it's much the same. You can have Jews that are anti-Zionist. You could have Jews that holding up signs that are anti-Zionist signs, but you can't have them engaging in behavior that discriminates or targets Zionists. So it doesn't really matter that they're Jewish and they don't believe in Zionism. They cannot engage in discriminatory conduct regardless of how they identify themselves.
well, let me then play a little devil's advocate for right? So then if we're talking about differentiating between speech and conduct, for instance, students standing and chanting "Globalize the Intifada," that's speech. Is that what do we do there?
What
Jewish students, let me give you this scenario. Okay, I'm a Jewish student at MIT. Um, every day I walk to class, and while I walk to class, I have to walk past people who chant "Globalize the Intifada" from the river to the sea. I go to the school administration. I say, this is hostile. This is anti-Semitic, even though I think they should really be saying anti-Zionist and educating the administrators on this new form of Jew hatred. But okay, what is the answer there?
The answer is in two parts. It's the conduct and it's the speech. The conduct is what's punished. It doesn't really matter if they're out there chanting, I love. If someone follows you around campus saying, I love you every 5 minutes, they're harassing you. They
Right.
are they are creating a hostile environment for you, even though they're saying that they love you. That's actionable conduct because what they're doing is they're violating codes of conduct of the school. They're potentially violating criminal law. They're violating the rules that society imposes on them, even though they're not saying something that most people would see as harmful. That's the conduct. So when you have a group of students yelling things on a daily basis, that's creating a hostile environment that is something that we are protected from by law. Now, the Zionist component comes to understanding the motivation of these people, which is that there is a hatred that's being manifest. It's not just a political expression or any speech. It's a hateful, there is no hate speech, but it's a hate motivator that what they're saying is targeting Jews as a minority, Jews as a protected class, because that's where Zionism comes in as synonymous with Jew. So that's the distinction is you're looking at the speech as a motivator of conduct, but you're punishing the conduct, not the speech.
Well, then let me throw another curveball at you. And I think it's important because I think people are thinking these things, right? We keep on coming back to saying Zionism is integral to Jewish identity. Zionism should be protected class. A Jew should be protected class because Zionism is integral. What about non-Jews who are Zionists? Is that their Jew? How are they experiencing anti-Zionism? Could they go and file a Title VI or a Title VII?
I think that's a difficult question, and that is what poses a difficulty to some extent. And we are in somewhat risky territory when we see other people identifying as Zionists who are not Jewish, because it depends a little bit in part on how they define their own Zionism, whether it's part of their religious practice, whether it's part of their belief. I think to some extent it has to do with the idea that you can make the argument that they believe in Zionism to the extent that Zionism is inherent in Jewish identity. What I'm getting at is the same as, I believe and I accept that for Catholics, the Holy See is the Vatican and the Pope is, the Word of God on earth. That doesn't make me a Catholic. That makes me someone who gives respect, who pays respect to that aspect of their belief. So one argument is that Christian Zionists or other types of Zionists are not looking at this as part of their religious practice. They're looking at this as kind of as allyship to the Jewish people. But even if you were to say, and I'm just thinking out loud here, even if you were to say that it is part of their belief system, that doesn't make it any less protected, because if it is inherent to their religion, to their religious belief, that doesn't put them in conflict with Jews. That means that that is a component of their religious identity, which is also protected. So I think you could make a very good argument in court that even a Christian Zionist would be protected if that Zionism is part of their religious practice. If they see it as a political belief, then they're an ally. It's not protected as a religious belief. But if it is part of their religious belief, we all Abrahamic faiths, all we have some things in common, and all of that is part of our collective faith, so that's protected by anti-discrimination provisions, by provisions against discriminating on religion. So we don't practice or worship the same way as Muslims or as Christians, but we have some core tenets that are the same. That doesn't make it unique. That still makes it protected for all of us.
Hmm. So as you're speaking, what's emerging for me is the tension between conduct and speech. And that tension it vivifies another problem, which is that I think what's happening is that standing on campus and saying the N word or saying the C word for women or saying the K word for Jews has become socially so abhorrent that it's rejected. And we're not there culturally, socially, where people standing and saying dirty Zionist Jew or dirty Zionist pig, it does not is not yet had that same cultural disdain that it doesn't hasn't. And what I'm trying to argue here is basically that what the law may need is culture. Right. So yeah, what were your
No,
thoughts?
you're absolutely right. And I think we were talking about this before the webinar began. I think that that's the missing gap, essentially, that over time we have come to understand that certain descriptions, certain words, certain conduct is unacceptable for other minority groups. But we have not yet gotten there with Zionism. We're still too used to anti-Semitism. We're still used to more traditional or classical anti-Semitic tropes instead of understanding what Zionism is and how anti-Zionism manifests. And I do say that I think that we are slowly going to get there. Because if you do look at the settlements that have taken place at university campuses, including universities like NYU or Harvard or Columbia, there is that growing recognition on college campuses that Zionism is a proxy for Jew. That when you're saying, kill the Zionists, what students are really saying are kill the Jew. We're only just starting with that realization. It took us, what, 150 years to get past the part when it comes to the civil rights of African Americans, of blacks, that certain things are unacceptable. We're just 4 or 5 years into defining that Zionism is, that anti-Zionism is wrong. We're at the very beginning stage of it. We haven't normalized it on college campuses, let alone in society.
Yeah, well, that worries me because it's been with us. I mean, what worries me a lot within the Jewish community is that they talk about anti-Zionism as an October 8th story, and it really isn't. And we've really been sleeping at the wheel for the last minimally 2 decades. And it, it, I worry that we may be a little too late because, we're just now understanding about that Zionism is a proxy, which brings me to the other question that we talked before we got on this webinar, this notion of proxy harassment. And you said that it comes from California, and this idea that, let's say I have a business and I don't want to, let's say, be overtly racist, and I just say, At my store, I don't want anybody with an afro. That's called proxy discrimination. Why can't we apply that same when we say Zionists out? Why can't we apply proxy discrimination to that?
The truth is we can, but we need to get to a point where we can where judges can understand based on society, based on common understanding, or at the very least through expert witnesses, that this is a proxy for a Jew. And the issue you pointed, it's very linked to the previous segment where we just talked about how we're not quite, well, I don't think we're quite at that stage yet. Neither of us thinks we're quite at that stage yet. But that's the problem, is that we do have this availability. This is a legal concept. You can argue that Zionist equals Jew when you're facing discrimination, but the problem is that it's an uphill battle because you still have to convince the judge, you still have to convince the university administration, you still have to convince society at large, and it ties into the you can file a lawsuit, but you need to have your ducks in a row. You need to be able to have those experts, that corpus of literature, of scientific or academic literature about this, enough so to convince a judge. And once you get to that point, you do see some good decisions that have come out over the years. Usually, when defendants who are sued for anti-Semitism, which is really anti-Zionism, have sought to dismiss cases, judges have ruled, no, wait a second, Zionist is proxy for Jewish, so we're not dismissing the case. All those cases settled. So there isn't an appellate record to show that, but there is a trial level decision at some point on a motion to dismiss or a motion for summary judgment that makes that proxy argument for us. So what we need are two things. We need kind of the right case to make that argument, and then we need to bring in the experts. We need to bring in people like you. We need to bring in the body of case law that's been established elsewhere and really make that argument. And it's uphill because having been doing this for a few years, the best cases are hard to find. There are a lot of people who are experiencing Jew hatred who are reluctant to be plaintiffs, or people who are happy to be plaintiffs, but they don't have the strongest claims. So it's not really easy to get to that point yet. But the corpus of law, I was just doing a bit more research today to see where we are in terms of the state of cases today versus a year ago. It's considerably better. We've got better decisions out there. We've got better settlements. We are trending, believe it or not, in the right direction, but we're nowhere near where we need to be to convince any judge on the face of an argument that Zionist equals Jew.
What do you think about people who say that settlements is not actually productive, that that is not what we should be pursuing?
I think it depends on the settlement. And I think if you're settling for money, unless it's a huge amount, you're not really going to make it's not really going to make a difference. To a university, especially if you've got a school with billions of dollars of endowments, that's also probably getting billions of dollars from Qatar, the Saudis, and whoever else. Paying 10 million, paying 100 million doesn't make a dent. So you really need to come back with a huge number. But when you change policies and then you're able to enforce those policies, and those are two different things, by the way. You can have a policy that defines Zionist as something that's protected. You can have a policy that has a Title VI coordinator, but then you have to go back and actually enforce the policy. So that's a separate issue because you need to continue supervising what's going on that college campus. You need students to communicate with you what's going on today after a settlement than before. But it does make a difference because schools look at one another. So when I'm talking to a private university in upstate New York that has not been sued, I'm telling them that, look, Harvard did this, NYU did this, Columbia did this, Northwestern did that, all of these settlements that came about as a result of OCR actions. So because the other schools are doing it, you can follow suit. You have this protection of the other guys are doing it. Their lawyers say it's okay, so you can do it too. And you're getting more and more schools that are starting to understand this and follow suit. So eventually you get to a critical number. The settlements do make a difference, but they're not working as quickly as a court opinion, which will tell you this is the law. And if you violate this, if you allow students to discriminate against Zionists, you will be in trouble. There isn't that decision out there yet.
I see. So, as we are coming to the hour where I want to open up to questions, so everybody on this as a webinar, please start thinking of the questions, start putting those questions in. Um, I guess not being a lawyer, being somebody who's more of a scholar and writer and educator who's working in the field of culture and trying to change culture, and you're in on the legal battlefield. I guess what I'm seeing from where I'm sitting is that there's these two approaches. One is we have to we have to explain to the judges that Zionism is integral to Jewish identity, and anti-Zionism is discrimination. Anti-Zionism is basically a form of Jew hatred. That's one approach. But then here's my question to you. A couple months ago, Stand With Us lost a pretty big landmark case against MIT. And the First Circuit judge produced these documents, about 56 pages, explaining why the judge dismissed the chart the case. And on page 30 of that decision to reject the case, the judge says, because there's no consensus that anti-Zionism is anti-Semitism, or I wouldn't say that, I would say a form of Jew hatred, but okay. Um, because there's no consensus, I can't treat anti-Zionism as a form of bigotry. So my question to you then is the approach that we need to show that Zionism is integral to Jewish identity, or do we need a consensus that anti-Zionism is a form of Jew hatred?
I think that, well, I think the MIT decision was flawed in many respects, and it's been widely panned, not just people who are in our, Jewish civil rights orbit, but other lawyers as well, that there were quite a few flaws in what the circuit court did. I don't know that that's going to get to the Supreme Court. I think that we will need another circuit decision that's contrary to that in order to make this an issue and have better law coming out of the First Circuit. But the problem is, I think that consensus helps. You don't need it. A good judge understands these issues without having the additional need for consensus or the additional need for 1,000 scholarly articles. But when you don't have a judge that gets it, then it hurts us. Then you do want to show to the extent possible that there is consensus, which is why I think a lot of us keep looking at these studies that show 90% of Jews or whatever the number is believe are Zionists. That shows to some extent consensus, and I think those studies are important because they do influence judges who, not just judges, but universities and employers who may not get it or who may have a resistance to saying, well, if there's someone who doesn't agree with that definition, there's no consensus. So when you do have these studies, when you do have the consensus, it makes it easier for a reluctant judge to understand. But legally, I don't think it is necessary, although you can get a bad decision. So I think it's the tension is twofold. We need a social approach. We need to go from the bottom up, to explain, to put out articles, to have lectures on college campuses. I love the IDF, but stop bringing in IDF soldiers. Bring in people like you who can talk about Zionism because that's what's needed. We need to define our identity. And the more you do that and normalize the concept of Zionist identity, then you have the studies, then you have the consensus. You may or may not need it, but that makes it easier for a judge or a school academic to understand.
Well, what about also bringing in people like myself or others, not just to talk about Zionism, but to educate them on anti-Zionism, on how this is the third era of Jew hatred. Now, you're probably thinking like a lawyer and saying, well, hatred is not something that can be outlawed. It's not something that can be prosecuted. You cannot prosecute a hatred unless, of course, you go into conduct, because we have free speech. We're kind of constricted around that free speech First Amendment. So I guess I keep on coming back to that tension. I keep on coming back to what's emerging from my conversation with you today is that um, culture really, really needs and that means writing more articles, doing more lectures, doing even speak outs, if you will, right? Talking about not just that Zionism is integral. Yeah, Zionism is integral to Jewish identity, but also explaining to people what is anti-Zionism. Now, when I shared my screen, I finished with a screenshot of that learning question posed by the teacher. How tell me about how the daily lives of Palestinians living under occupation. And we go to the school administrators and we go to the teachers and we say the word anti-Semitism. And I think that I'm not about policing speech. I'm not, I'm from the former Soviet Union and I believe in freedom of speech, absolutely. But I think we have to be much more intentional when we speak to administrators to explain to them, hey, I know that you understand that Jew hatred looks like this, but you have to understand that this hatred is very complicated and has the capability of mutating. This is the latest mutation of this hatred, and it uses libels to stigmatize, demonize Jews. You know this. You know that whenever there's a Gaza walkout at a school, whenever a teacher brings in a unit in which, that with a disappearing map of Palestine, what ultimately you hear from Jewish students is that they feel that there's been a target placed on their back. They walk in the hallways. They are being called dirty Zionists. The Robert Kraft ad, remember that one during the Super Bowl where
Mhm.
the boy got a sticky that said dirty Jew? It's not dirty Jew, it's dirty Zionist. That's what's going on right now. The language shift, it code switched. It's a code switching because the wily Jew hater understands how that the language, oh, excuse me, I'm so sorry. So sorry. The wily Jew hater understands that the language shifts, right? I'm so sorry. The um the wily Jew hater understands that the language must shift. Wilhelm Marr, he coined the term sorry, maybe it's as something from my brother's calling, but I apologize. The wily Jew hater changes the language, code switches. Wilhelm Marr came up with the term anti-Semitism in order specifically to package an old hatred. When Wilhelm Marr coined the term anti-Semitism, he said, I have no problem with Jews as a religion. In fact, that's not my issue. That is what the anti-Zionist says. I have no problem with the Jew who eats their bagels, who does their Hanukkah candles, although Hanukkah is like the most Zionist holiday. I don't have a problem with that. My issue is with the Zionist. So I think that it keeps on coming back to me in our conversation with you is that we need much more literature. And by the way, there's a whole movement within law of people asking, like I participated in an amicus brief where part of that brief I wrote about the history of anti-Zionism to educate the judges. We need to do that. What are your thoughts?
Oh, absolutely. I mean, it's educating the judges, educating the public, also being activists. I've been part of the End You Hated movement from day one because, as a lawyer, it's frustrating. The law doesn't protect us to the extent that it should. But the same as with other civil rights movements, you need that activism. You need to explain to people. You need to have that critical mass of information out there that makes your point. And when you do get to a point where it makes a difference. I was looking at the language from, there was the lawsuit against Berkeley that settled earlier this month, just what, a week or two ago. And there's language there that Berkeley agreed, and I quote for this, bans on Zionists have historically been used by some individuals and institutions as a pretext for excluding Jews, and that such pretextual exclusionary bans can violate university rules. That's one example just in the last few weeks of administrators of schools that get it and are willing to use that language and are willing to go in the right direction with policy. But this shows you how far we've gone in 4 or 5 years with help of people like you who submit those amicus briefs, who educate about Zionism and anti-Zionism. But we need to do a lot more. People need to be talking about this. So when you see that classroom discussion, you need to not confront, but you need to address that with a school. You need to file a complaint. And while I love the idea of people doing it by themselves, and I don't think everyone needs a lawyer to file a complaint, especially when there's a forum to do it, I think it behooves us to be smart about the way we handle it. And we want to include these arguments. We want to include what Zionism is and how anti-Zionism is the manifestation that we're experiencing. Because the more we have that in writing, the more we document that, the more we complain about it, the more difference it makes.
Great. I think people really want a Q&A. So I am looking at the questions. I'm opening it up to the audience. So I think the first question I'm going to give to you, Gerard, and then I'm going to take the second question about what makes occupation a libel. Um, this question is from an anonymous attendee. It says, is it unusual that so many anti-Semitism claims in federal court are getting dismissed on 12b6 motions? Would they typically be allowed, first of all, you must have to explain what that means. Would they typically be allowed to go forward with discovery if we were talking about another group? So if you could explain that to us.
A 12b6 motion is a motion to dismiss for failure to state a claim, which means that if the facts are true as you're alleging them in the complaint, then you have not pleaded the complaint well enough for there to be a remedy at law. And the issue with that oftentimes is that you do have, unfortunately, a good number of complaints that are brought from cases that are marginal, and cases that are more speech than conduct. And that's, I think, where the issue is that a lot of cases have come up, in, especially in the last 2 years. It's great that there are more people, more attorneys who are taking on cases, but you also see more marginal cases being brought, cases that lose, cases that are not strong, cases that focus on the language and not the conduct. So when you are bringing a complaint and you're focusing exclusively on people chanting on a college campus, but you're not mentioning the effect it had on a student, the harm that was suffered, if all you have in that complaint is they were chanting bad things, it's going to get dismissed. So a lot of the complaints that we've seen be dismissed is that they didn't meet all the requirements. They didn't plead the damages, the injury, what actually happened to a student who has standing to sue.
And the second part of that question is, would they be typically allowed to go forward with discovery if we were talking about another group?
I think you have the same issue if you don't plead the complaint well. If you have, for example, a black student who is suing based on people were saying racist things, they're going to be in the same predicament. They have to show how it actually impacted them, what the harm was, that they were prevented from obtaining the benefit of their education, that there was this either one incident that was so severe or that the atmosphere was so pervasive that they were prevented from having the same experience as any other college student. And that's what a lot of these complaints are missing. Now, if you're pleading it well and you are surviving a motion to dismiss, then you get discovery. But I don't think it's a matter of Jewish versus other groups. I think a lot of these complaints have been dismissed because they didn't include all the elements that needed to be included.
Got it. Okay, let me take this question from from one of the participants. Please explain why calling Israel an occupier in the West Bank and Gaza is a libel. Many Jews and Israelis refer to the occupied territories of those lands which Israel won in the 67 war as occupied territories. I want to take that, this is a complicated question, but I want to take a few steps back and take the opportunity to educate the people on this call today about what is a libel. A libel is rooted in always a little bit of truth and then twisted. And before we talk about Israel and the occupation libel, I want to talk about, for instance, the Christ killer libel. The reason libels work is because they are rooted in that little bit of truth. Judas did betray Christ, did he not? Judas betrayed Christ. Now, that is a little bit of that truth. And then it is widened and said, all Jews killed Christ. That's the Christ killer libel. Let's take a look at the blood libel. The blood libel originates, the first example originates in the 12th century in England with a boy, William of Norwich, who goes missing from the town of Norwich. His body is found crucified, drained of blood. It really happened. And guess what? He also happened to live next to Jewish people at the time. And guess what? His family worked for Jews at the time. So the libel always is created based on that little truth. I want to talk about the doctor's plot libel, for example. In the Soviet Union, Stalin deployed this accusation, the following accusation, that Jewish doctors were planning to kill top level Kremlin leaders. And the reason you can get away with that libel is because there's a little bit of truth in that. And what is that little bit of truth? Was that one of the top, indeed, one of the top Soviet Kremlin leaders did die, and he was being under the care of a Jewish doctor. And that is the nature of libels. They take that bit of truth and then they twist it because the goal of a libel is to demonize. Now, let us take a look at the accusation of Israel an occupier. In 1967, Israel fought a defensive war. According to the Geneva Convention, Fourth Geneva Convention, if you fight a defensive war and win territory, you get to decide what you do with the territory. When we're talking about Judea, Samaria, or the West Bank, what Israel decided to do was institute a military occupation. But people who deploy the occupation libel, they're not in nuance. They don't understand that nuance. They use the term occupation and they mean all of it, from the river to the sea. So it's rooted, again, you see, it's rooted in that little bit of truth that there is a military occupation. It is legal. They will say to you, but is it moral? Right? Now, if you think about what I said and what I began tonight with, which is that there are three forms of Jew hatred, and each type of Jew hatred casts the Jew as violating the tenets of the, the tenets of the day. Today's tenets is human rights. The word occupation is very charged. When you deploy that term, it's what I call a checkmate move, because this isn't criticism of Israel. This is a libel, because the goal of a libel is to demonize. That is a checkmate move. When you tell Israel that they are a colonizer, there's nowhere to go after that. Same with apartheid, same with genocide. And the reason those particular libels have had such a life, have been so sustained, is because there is that bit of truth. Because if you look at the recent conflict between Israel and Gaza, way more Gazans have died. Way more Gazans have died. So you can get away with that genocide libel. But these are libels because the goal is to demonize. No different from blood libel, Christ killer libel. All right, here's another question. Um, Thank you for your thoughtful analysis. It seems though we are losing the battle from minds to snappy slogans and a flood of social media lies featuring tragic images designed to inflame hate against Jews. Simply put, don't we need equally compelling, easily digestible defenses? Why can't we present an appropriately compelling, snappy, and media-savvy case for Zionism? Um, I don't know if you want to take that, Gerard. The issue, I've argued this, is the issue is that we have always been on the defense. That's our biggest problem. And I know, Gerard, you and I may disagree on this right now. I actually think, and maybe it would work in court, but I think that the more that we sit around defining Zionism, the more that we are putting the lens on ourselves. Right, I'm talking in the culture war, not in the legal battle. When we are out there saying, this is what a Zionist looks like, let me define Zionism for you. And by the way, there's like a plethora of definitions on Zionism, right? The more we do that, the less we put the lens on our accusers, on the anti-Zionists. So, to your question, Martin, I don't think that we need savvy posts about Zionism. I think we need savvy posts about anti-Zionism. That's what I believe personally. From 20 years of being in what I call Jewish advocacy, is that we have made the mistake of turning our pockets inside out over and over and over. And how are we doing this? By defining what Zionism is, by explaining Israel's history, by explaining why Jews are indigenous to the land of Israel. And the more that we are doing this, the more that in many ways we participate in our own trial. I don't know, do you want to say something?
In, in large part, I agree with you. I think that, anti-Jewish imagery and language is visceral. It's not academic. They use academic terms, but academic terms that no one really understands the nuance of. They label, genocide or apartheid, and then they show a picture of a wounded child. So if you argue that with facts, you're going to lose. You're going to lose the audience because the audience has already been shocked by the image. It's very hard to come back with an academic or a definitional response. If someone says Israel an apartheid state, standing there and debating, listing 20 reasons why it's not, you're not going to win that person over, and you're probably not going to win someone else over either. We have to change the way we're looking at this. And part of that is not a victim mentality, but I'm a Zionist, so F off. It's not standing there defining and defending everything. It's asserting our right and asserting our legal right. If someone is a member of another race or another religion or another minority group, they don't have to stand there and define or explain what they are. It's enough for them to be that. And I think that in court, yeah, in court we have to explain it. But when it comes to interactions on the street, the more you explain things, the harder it is to actually convince someone because it's that one identity based. We all have come to understand identity based expressions, whether it's LGBTQ, it's sexual orientation, gender, any other type of identity. It's easy to understand. So maybe that is the direction we need to go, and we need to be assertive in our Zionism instead of being on the defense of explaining everything.
Well, here's the other question somebody else is asking, which I guess challenges this. The conversation has been largely about defending Zionism. However, what about obtaining legal recognition? Again, we talked about this it is the issue that we need to obtain legal recognition that anti-Zionism is actually not about Zionism, that it is a hate movement that constructs its own demonic description of Zionism that is not actually addressing Zionism. So let me just unpack that for people. I think that there's kind of been this whole debate about the hyphen with the word anti-Zionism, with the hyphen, without the hyphen. When we keep the hyphen, we kind of promulgate and further this idea that anti-Zionism is opposition to Zionism, but really it's I say it's not opposition, it's the demonization of Zionism. So, Gerard, what do you think about the fact that what we really need to do is not defend Zionism, but actually expose that anti-Zionism is its own hate movement that constructs its own demonic description of Zionism, which dovetails to this other kind of conversation that's happening online, which is maybe we don't need to protect, let's say, Jews. We need to have another protection class just for Zionists. What do you think about that?
I think that I like the idea of integrating Zionist identity more and having anti-Zionism defined as as a type of hate. But from a legal perspective, it's not religion, it's not national origin. You can make arguments that it's ethnicity based and national origin, but the more you try to form a separate definition about it or have it entered as a protected class, the more you run into an argument that that's not the type of thing that is usually understood as a protected class. And because some people politicize it and make it political, that's when you enter the realm of for an elected official to make that determination, they're going to see this as a political issue. They're not going to see it as one of religion or identity. So I think that's the challenge is we want to express Zionism in a way that still ties to Jewish identity and not have it as its own thing.
Right. I think that question kind of originates from perhaps, and I'm sorry if I'm misunderstanding the question, kind of also a misunderstanding of law. And that is that currently the way that you get protection is based on a certain group identity, right? So in other words, acknowledging that anti-Zionism is a hate movement without saying, well, who is it hating? Who is the identity group? How is that actually manifesting? How is it discriminating against this identity group? Kind of misses that point because in its current ways, the way that Jews or any other group can get their rights, their civil rights, is by proving that, yes, anti-Zionism discriminates against me because of my protected identity as a Jew, right? Would you agree with that?
Because of my protected identity as a Jew who is a Zionist. Yeah.
Because that's the way the current laws around discrimination, that's the way that they are basically framed. That's the way that they are that they exist. That it's not about, oh, there's a new hate movement, so now we have to recognize this new hate movement. But hey, who is it targeting? That's the question. Then, okay, let's say we recognize this hate movement, but then who is the target of this hate movement, right?
That, that's an excellent way of putting it. And for the DSA hates Republicans, MAGA hates Democrats. None of those are protected groups, so you can have that hate and not be protected from it, because we only recognize certain things as protected classes. So when we don't have that connection with Jewish, then you're not going to have that. You can have anti-Zionism as a understood to be a hate movement, but unless, as you said, unless you have that understanding of what is being protected and it
Yeah.
is a legally cognizable protected group, it's really a meaningless definition.
Okay. Um, I'll take one or two more questions. This is an important one. Thanks for this important information session. We have filed suit against the public high school my two children attended. Are there any rulings or recent settlements that help establish what the responsibility of public high schools or any schools have in protecting their students? For example, student groups to organize and operate in the school, like SJP and the like, that have been deemed as anti-Semitic organizations about allowing anti-Zionist protests in public schools.
There are cases, there have been OCR settlements, there are some pending cases in New York, in Pennsylvania, and California. I think the challenge there comes back to conduct versus speech. When you're looking at SJP, it's not enough that they exist as a group and say certain things. They have to behave in a way that is contrary to the legal rights of Jewish students or some other student. And the mere existence of a group does not, even if we understand it as a hate group, or even if the Southern Poverty Law Center or the ADL lists it as a hate group, that's not by itself enough. You need to actually show that there was some conduct that caused harm. And I think even looking outside of Jewish identity, that's where you will find case law in K-12 and the same as anywhere else, that if there was a identifiable group, in this case Jewish, that experienced conduct that they should be protected from, those opinions are out there. That precedent is out there. If what you're looking at is more speech, then it does become a little more difficult because you don't have that corpus of rulings. You have some settlements which obligate schools to do better investigations or to do better in terms of policies, but you don't really have that precedent yet. So that's something that's still a work in progress.
Okay. Um, this final question is to you, and then would like to answer it as well. But it's really, will Gerard be able to consult with me and our attorney on our case? And this kind of, Gerard, how can people get in touch with you? How can they get your counsel, your advice? And then I will just say that in addition to the legal battle, what is so critical is the education battle. Right. Thank you for putting that. I'm also going to put my email. One of the things that we are doing, and I am as a co-founder of Stop Antizionism, is we issued a declaration, the first ever, that states that anti-Zionism is a form of Jew hatred. Why? Because we want to have that consensus. So I'm going to put, please go to, I'm going to put my, our website, www.stopaz.org, and take a look at our declaration. Also, I'm going to put my email. I think one of the most important things that we can do for our community is educate ourselves on how to use the correct terminology and language. What is a libel? How does it function? What is anti-Zionism? Why is it the third era of Jew hatred? So with that, I am going to thank everyone for coming to this important webinar. Jared, thank you for all your amazing kind of letting me kind of challenge you, push back on you a little bit. I see a lot of exciting new developments happening in the education field and in culture field, and I think they're definitely going to shape and influence um, how the law is going to behave in terms of protecting Jews.
And thank you, Naya. We can't get there without the work that you do, and that's so crucial for all of us right now. So I really appreciate everything that you're doing in this important fight.
Thank you so much. Thank you, everyone. There will be a recording and we will send it to all who registered.
Thank you all. Good night.
Good night.